to Crime in Court. My name is Heather, and this is another update in the Karen Reed case. Karen Reed was in Norfolk Superior Court again this morning. So this is a recap of her hearing, and we're also going to go over a new filing from the Commonwealth, which is just bonkers and jaw-dropping, and I can't even believe that we're seeing it happen. So we'll get to that at the end. We'll watch a little bit of Turtle Boy stream because he had a guest on and they were talking about it, so it was really interesting. So here we go. Let's before we begin, please hit the like button because it helps your algorithms as well as mine, and I really appreciate it. All right, so here we are. This is the Karen Reed trial. Before we begin, let me just start by saying, so Karen Reed's she's the woman in blue, if you're not aware, and the two next to her. So usually it's Alan Jackson and David Yannetti who are in court with her. However, David Yannetti had some prior something he couldn't attend. I think he might have been in trial or something. And then so the other thing is, Alan Jackson didn't come in from California, so he was on Zoom. Which, if you listen to Judge Canoni in the beginning, it sounds like she's pissed that Alan Jackson didn't attend or that someone wasn't here. So anyways, the people that are in attendance with her today, her name is Tanis Yannetti. She is the sister of David Yannetti, and she works out of the same law firm, as well as Ian Henchy, who is also one of their colleagues who works out of the David Yannetti or Yannetti at law firm, whatever it's called. I can't remember. So that is who is representing her today. We do have Alan Jackson on Zoom, like I said, and just listen to Bev's reactions about the fact that he's on Zoom, because I don't think she likes it. So, there weren't really big truth bombs in this one. I thought, after the last couple ones, we thought there might be, but there really weren't this time around. But there were some interesting things that happened. So, let's listen in. It's real quiet at first. In fact, whoops.
Good morning, Mr. Lally.
Good morning, Your Honor. Laura McLaughlin for the Commonwealth.
Good morning, Mr. McLaughlin. Good morning, Ms. Yannetti.
And good morning, Your Honor. Ian Henchy on behalf of Karen Reed, Attorney Jackson, to be with us on this.
The sound will get better.
Good morning, Mr. Henchy. Good morning, Mr. Jackson. And good morning, Ms. Reed. All right. So, in court, our counsel will argue the motions for today. There's only Mr. Henchy and Ms. Yannetti. When I set dates on the modified scheduling order, I set dates that were convenient to the parties in recognition of mainly defense counsel's trial schedule. And last week I renewed the Pro Hoc Vici motion, but I see Mr. Jackson chose not to be here today, and so counsel will argue the motion here this morning. But before we begin, I have been told repeatedly from both Mr. Jackson and Mr. Yannetti, and I do understand completely that Mr. Yannetti cannot be here today. He's certainly excused from being here today. But I was told that there would be a motion.
But that means, Alan Jackson, you're not. You should have been here, is what she's kind of saying right there.
Motion a motion to dismiss based on egregious government misconduct. I was told that by both Mr. Jackson and Mr. Yannetti. I asked Mr. Yannetti how that motion to dismiss was any different than the motion for sanctions and motion to disqualify the district attorney's office. He assured me that it was in fact different. He assured me that he would put in the body of the motion how it was different, and he assured me as recently as last week that motion would be filed later that day. So that motion has not been filed. That motion then is waived. So what we have today are two motions regarding Rule 14 obligations. So who's going to argue? Is it Ms.
Doesn't she sound mad? Like already going in, like, I was told I was getting this thing multiple times and I haven't gotten it. So she's talking about the egregious government misconduct that both Yannetti and Jackson have mentioned in previous hearings. However, Tana Cianetti will speak to that in this, in her, when she gets up to argue. One other thing I wanted to mention, I don't think I had put up any updates anywhere on my page because it was crazy last week, but so the last hearing that we had, the defense was requesting the phone records for a few individuals, including Proctor. What is it? I think no. It was the Alberts, Chris Albert, Kevin Albert, sorry, Brian Albert, Kevin Albert, the brother who is the cop, and then Berkowitz, who was the chief at the time. So they, she, and there was someone else. I think it might have been Proctor or Tully, and she agreed to handing them over. I can't remember now why is that. Like it's too many cases I'm trying to follow at once. I think all my information gets blurred, but it was, I believe it was 4 individuals, and she agreed to compel the Commonwealth to turn it over. All right. Anyways, getting back to arguments here.
Giannetti or? Okay, so I need you at a microphone. So I will hear you on the motion where you're looking for notes, reports, memoranda, and logs.
Thank you. Your Honor, at the outset, I just want to note that, as this court is aware, we have a motion pending before the court to disqualify the Norfolk DA's office from this case. Our position, therefore, is that the DA's office should not be participating in this case or arguing any motions, including this one. And I raise this issue just to alert the court that we are not waiving any objection to their continued involvement in the case.
Okay, so I haven't decided that because I was waiting for the motion for egregious conduct, motion for sanctions or motion to dismiss based on egregious governmental misconduct, because I needed to be assured that that was different than the motion to disqualify. If I had known it was not coming, and maybe no intention of filing it, I would have decided that motion by now.
Your Honor, it was a strategic decision
Okay.
for us not to file that motion. It's not because it wasn't meritorious. It was a strategic decision.
All right. You made representations that you were, therefore the other motion, I have not acted on that yet.
I just want you to note the objection, please.
Yeah, the objection's noted, so please move on to the merits
Yes.
of your discovery request.
Absolutely. Your Honor, we're asking for material that fits squarely within the parameters of Rule 14. Statements were made to investigators in this case, including to Mr. Lally and to his staff, and in certain conversations, the state police were even present. Statements of witnesses are simply discoverable. Although they lodged general objections to each of our requests, and these were really boilerplate objections, the Norfolk DA's office appears to be arguing that these witness statements contained in their notes of their conversations, multiple conversations, are all work product. Neither this court nor we are in a position to judge whether the notes are strictly work product without actually seeing the notes. Work product is defined as legal research, opinions, theories, or conclusions. And to be clear, we are not interested in the Norfolk DA's office's opinions, theories, or conclusions. To the extent that these notes contain work product along with the statements, we are fine with the work product being redacted. We are not interested in their work product. But it is important for us to know whether their notes contain any statements of witnesses. And if they do, they should be turned over to us. Otherwise, discoverable material is not off limits simply because a prosecutor writes something in the margins of a document. That would give an attorney the power to keep otherwise discoverable materials out of the hands of a party who should legally be entitled to see the material. At a minimum,
That almost sounds like Lally was going around and wherever there was a witness statement, throwing in stuff in the margins to say, strategy here, whatever strategy or conclusions are, this legal, strategy, so as to prevent it from being discoverable. However, that's what she's saying. That's almost what it sounded like she was implying he was doing, was to bury those witness statements by putting work product information next to it in the margins so that they could say, oh, this is all work product, but really it's not.
Your Honor, this court should order the Norfolk DA's office to disclose whether its notes contain any statements. They have not disclosed that. If the notes contain any witness statements, and if the Norfolk DA's office is objecting to producing them to the defense, then we're asking this court to have the DA's office produce those notes to the court so that this court can conduct an in-camera review of their notes and evaluate whether they are truly all work product or whether there is, in fact, discoverable material contained therein. Beyond that, Your Honor, we would rest on our motion in a brief.
Okay.
So she's asking for Judge Cannoni to compel the Commonwealth to turn over these notes, redact the information that is work product that was preventing you from turning it over. Just redact that part. Give us the part that isn't work product, the part that's like witness statements and communications between Lally and his witnesses. So that's what they're asking for. And she's saying, if you don't want to make them give it to us, at least make them give it to you, and you can look at it behind closed doors, review it, and determine whether there is any information that should be discoverable to the defense. That's what she's asking here.
Thank you.
Thank you.
Mr. Lally, your response, please.
Yes, sure. And Your Honor, I'll be brief. So essentially what the defendant's motion seeks is, and I would object to the mischaracterization of every single phone call or conversation with a witness as an interview with a witness, but I'm not even sure what half of these are referring to, as I don't recall any of those specific meetings occurring. But if there were meetings, any meeting with a witness post-grand jury was in reference to either harassment that they were sustaining as a result of actions of others in this case, or as a result of a simple explanation as to Rule 17.
He brings up that damn witness intimidation again. He's talking about if there's any information in there which with the witnesses is about witness intimidation in my notes. Come on.
Motions that have been filed for.
He hates Turtle Boy. Like, he talks about Turtle Boy every time at the Karen Reed trial. He's obsessed with him.
Or individuals' phones or phone records or other third-party records that they were the subject of. It's a boilerplate response because it's a boilerplate law that applies in this case as far as work product that applies to each and every one of the requests, with the exception of number 8, of which the Commonwealth has no objection to that.
Explain to me how work product applies.
Your Honor, work product applies and specifically in reference to, it's contained within, and I would largely rest on the Commonwealth's motion, but it's contained within what's cited as Banks v. Lang in regard to interview notes in preparation of testimony is work product under the case law, under the rule of criminal procedure. Whatever notations may be contained within those, but essentially these are not statements as are defined under Rule 14 from any of these conversations with witnesses. Rule 14 doesn't apply to these statements, number one. But secondly, if there is any content, it's either already been provided through the course of the police report, grand jury minutes. There's nothing
really
different than what has already been provided. And then secondly, what the case law states and what Rule 14 states is that these types of conversations with witnesses, whether reduced to writing or not, are within the ambit of the work product doctrine.
All right. Any response?
What did he just say? He just rambles and rambles. I don't know what he just said. Okay.
Necessarily have to, but I just want to see if you want to.
I would just say, Your Honor, their opposition to our motion does not even acknowledge whether there are statements or not statements. I just heard Mr. Lally say that there, in fact, are statements. So I am going to ask again that this court take those notes there and go through it and in camera and decide whether, in fact, all of it is work product or whether there exists within it discoverable materials with statements of witnesses. And I find it hard to believe that there wouldn't be any statements of witnesses concerning this case. Thank you.
So he told on himself, saying that there was statements from witnesses in his notes. However, in whatever filing they did back, in response to the defense's filing for these items, so they have a chance to respond. So in their response to the defense, they must have, said that there was no witness statements, or maybe they didn't even answer that part. That's what she was saying, was that they didn't even, address whether there were witness statements, but just now he admitted that there were. So we want you to look at look at his notes and let us know.
Do you want to respond at all?
Your Honor, again, with reference to the, as they term them, interviews, but essentially phone calls with witnesses, these were in regard to explaining to them the Rule 17 process, explaining to them what counsel had filed, what types of records were being requested. It was, in large part, me talking as far as explaining the law and things of that nature. There were not any statements related to the case or any testimony that was discussed or anything of that nature. The one thing that I was referring to is there is one request that does deal with a meeting which involves preparation of a witness or grand jury, and whatever that witness indicated in the course of that was testified to before the grand jury and is contained within the minutes and contained within police reports of interviews with that same witness. So there's nothing to report.
All right.
Okay.
All right, the next motion is the Commonwealth's motion for reciprocal discovery. But before we begin with that, Mr. Lally, could you tell me what reciprocal discovery?
Before we begin with that, let me tell you that the defense is not required to hand over discovery until the Commonwealth has completed their discovery dump. So as of this hearing today, this morning, 20 something days from trial, the Commonwealth is still turning over discovery to the defense. So they just received a thumb drive this morning, and previously last week they got like 500 more pages from the defense to go through. So legally, the defense does not have to turn over their discovery until the Commonwealth has met all of its discovery requirements, and we don't know if they are done yet or not, and they have to let us know that they're done. So that's kind of a little background on that.
Has been provided to the Commonwealth at this point.
Nothing. Absolutely nothing.
All right, so trial is 3 weeks from today. When did the Commonwealth provide its certificate?
So the Commonwealth
compliance.
is unable to file a certificate of compliance at this point. The one, I would say, sort of primary piece that we're waiting on is there were 2 rounds of DNA testing that were done at the Bodie Lab in Virginia. One of those was completed. That was in regard to the defendant's taillight. That was finished, I think, first week of March, and counsel already has all of that. The second piece is in relation to the hair from the rear of the defendant's vehicle. Just for sort of review purposes, that was something that had gone or undergone sort of typical DNA testing, which is autosomal DNA testing, which is taking the profile from, or attempting to take the profile from the nucleus of the cell, and it relates to essentially both biological parents. That sample was of insufficient quality or quantity to generate a sample under the autosomal, so we had asked, and the court had ordered, for the mitochondrial DNA testing, which goes to the maternal side only, and the Bodie Lab is able to do that. My latest update from that, and I say all that just to build up as to a sort of caveat as far as the testing is concerned. So
That's Judge Canoni breathing in the mic. She does this every hearing. Just listen for it. At some point, she just really breathes loudly in the mic.
Initial estimate as far as the testing was would put us several weeks out. We had asked that it be expedited. We had paid for it to be expedited. And the quickest that they can turn around a report would be sometime in mid-April. The caveat to that is whether or not there is a...
Isn't that when trial starts? April 16th, mid-April? That's a little too late to be handing over your latest or your last little bit of discovery, I think.
Sufficient quantity and quality for them to generate a mitochondrial DNA profile from the sample. That I should have an answer to, I was told, by the end of the month. So hopefully by either the end of this week or very early next week, because obviously if they aren't able to generate a mitochondrial DNA profile from the sample, then there's no reason to generate one from the victim and do a comparison. So that would sort of end it there, and then we would then be able to file the certificate of compliance.
All right.
So they have not filed their certificate of compliance, whatever that means. I think that certifies that we've turned everything over now to the defense, which they have not done because they're still waiting on these mitochondrial tests on the hair that was on the bumper, which is ridiculous because that car went from... So even if she did hit him, let's say she did hit him at midnight. She still got up at 4 a.m. and drove all the way around town looking for him, and then came home. After that, she went to her parents' house, which was a 45-minute drive away from Canton. And then after that, it was on another 45-minute tow truck ride to the Canton Police Department, which Canton was supposed to have been recused. So there's a lot of fishy stuff going on. And the taillight, we all know the taillight was planted. So anyways.
Every other aspect of the case, though?
Every other aspect of the case, as I mentioned, there was a number 8 in the defendant's motion to compel that we should have to them by the end of this week, if not earlier. So every other aspect of the case as far as discovery goes should be done from the Commonwealth's perspective. And that's the reason that I filed the motion, Your Honor, at this time, understanding that they're not obligated under the rules of criminal procedure to provide anything, but given that we have an April 16th trial date and I have nothing as far as any sort of reports or notice of experts or testing or anything really at all, I'd appreciate being able to get that, review that, or at least see it, prior to.
I think the defense would have appreciated you not fighting them tooth and nail for every gosh darn thing that they asked for. Because this whole time, they've been asking for discovery, and you, Mr. Lally, have been holding back and not turning it over. So for him to be like, oh, I would really appreciate it if they would turn something over. It's like, get out of here, dude.
The day we're impaneling.
All right. What do you say, counsel?
Your Honor, as you know, we do not owe them any reciprocal discovery until they file a certificate of compliance, which has not been done. I mean, we have received hundreds of pages of documents. I mean, 4 days ago, we received like 400 pages of documents we haven't gone through. Counsel just handed us a thumb drive with, I don't know what's on this thumb drive. We have to go through that. So we haven't given any reciprocal discovery because we are not obligated to do so.
Do you intend to call experts
Yes.
in areas other than DNA?
I'm going to have to defer to Mr. Jackson, who is on Zoom.
All right, but counsel to arguing these motions was to be present here in court today, right?
Your Honor, if I can be here for just a second on that issue, Mr. Lally made it very clear that given the fact that he was not in compliance with his discovery obligations, that this motion was not to be heard today. So this is sort of coming out of nowhere.
No, hold on. So Mr. Lally doesn't decide what motions were to be argued. Today was for all non-evidentiary pretrial motions were to be argued. This was filed timely. This was on for today. If you feel that you cannot argue it, that's a different story. So you are muted. All right. Mr. Jackson, you're muted.
I don't know how I got muted. Yes, we are intending to call experts, and there are going to be experts that are in areas other than DNA as well. But we haven't provided discovery because we don't even know what the 400 pages that or 500 pages that we just got 3 or 4 days ago include, nor the discovery that was handed to us this morning. As soon as the Commonwealth gets finished with their compliance obligations, we will then comply with our discovery obligations. We have every intention of doing so, and we're fully prepared to do so. We're waiting on them.
So once you get it from the Commonwealth, you can have it in a matter of a day or so, other than the DNA?
Like what? Like she's not mad at the Commonwealth for not handing their stuff over, but she's mad that the defense hasn't turned their stuff over, even though they're not obligated to yet. And then she's like, can you turn it over in a day?
Well, I don't know if I can do it in a day, but once we have...
You do know, if you're calling witnesses, you know who you're calling, correct?
I have an idea who I'm calling, yes.
All right, and you've engaged experts, so you've been working with experts, so you should have all that information ready to disclose, correct?
We're in the process of getting those decisions finalized, yes, but some of them are going to be predicated on what the Commonwealth discovery and the totality of the Commonwealth discovery looks like.
No,
that's their obligation.
No, I understand. All right, but you will be calling witnesses and you will be calling expert witnesses?
Absolutely.
All right. What is your estimate as to how long this case will take to try?
I assume if the Commonwealth case, I'm just throwing a dart at a dartboard, but based on what I know, if the Commonwealth case takes 3 to 4 weeks, I think our case would probably take 2 weeks.
Okay. All right. Mr. Lally, I suggest that you get that information as soon as possible. It could be that I strike it, but I would hear from the defense on that as well. But at least find out if they're able to do the testing.
Yeah, sure.
All right. All right. Thank you. You have your next date. We'll see you then.
All right, so that was the hearing today for Karen. I mean, not too eventful, not any big truth bombs like the last one we had, but very interestingly, we had, I just learned that there was a filing from the Commonwealth regarding a buffer zone. So let me actually back up a little bit. This is the Turtle Boy show. I'll start it back here. All right, so this is the Turtle Boy show. He was streaming live today too. He was streaming the or not live, but he was streaming live the hearing. What was I gonna do? Oh, this is on his channel. His guest's name is Lauren De Laguna, and she has her own YouTube channel. I think she said something about she's going to be an attorney in Arizona and some other state soon, but I don't know what her channel is. I just saw that she is, you can see in her right there at Lauren De Laguna is her name, and you can click on that if you go to Turtle Boy's thing and go and subscribe to her page. Anyway, so here is their discussion about this new Commonwealth filing for a buffer zone outside of the courthouse.
Examination is going to be really interesting. I really can't wait to see Unetti at work. It's going to be fun.
I know. Oh, it's going to be bad. And so when the hell are they going to argue this buffer zone thing if this is the last hearing? Like that, the buffer
Talk
zone
about
thing.
a First Amendment violation. Holy shit. That is
Yeah.
so egregious. There's like, even in law school, you discuss, hey, can you prevent people from having signs in the courtroom? And it's like, okay, yeah, but you know, keep in mind the First Amendment, people are allowed in the courtroom and it has to be for very serious issues in order if like a trial cannot go on. To say 500 feet, you can't be that is.
That's what they want. Like they're asking down here. Where's he asking? Yeah. The Norfolk DA's potential witnesses of the evidence within 500 feet of the Norfolk Superior Court complex, which includes the parking area behind the Registry of Deeds building during the trial of this case. I mean, this is wild. So the Commonwealth requests prominent posting of Section 13A in and around the courthouse immediately before April 16th and during the pendency of this trial to notify any persons planning to picket, parade, or attempt to influence any jurors or otherwise impede, interfere, or obstruct the administration of justice have actual notice of the possibility of prosecution for such actions. Further, the Commonwealth requests any order prohibiting any individual from demonstrating in any manner, including carrying signs or posters or making statements about the defendant, law enforcement, the DA's office, potential witnesses, or the evidence within 500 feet.
This is so egregious. This is such a violation of our amendment rights, the amendment to free speech, to be able to protest our government. It was the number one most important thing that our colonists believed we needed, because it's the First Amendment. So here, I can't believe we're still fighting this all these years later, and with the Norfolk District Attorney's Office.
The Commonwealth also moves in for an order prohibiting anyone anywhere from prospective jurors gather the wearing or carrying of papers, water bottles, tote bags, signs, buttons, pins, T-shirts, sweatshirts, hats, or any other attire or item that contains any images or writing that suggests a favorable or unfavorable opinion of either party. Wild that you can't wear a fucking Free Karen Reed sweatshirt in the Registry of Deeds parking lot. That is what this order is asking for.
Or
And it's
500 feet away, you can't wear a Free Karen. You can't even like walk down the street wearing a Free Karen Reed shirt and then be within 500 yards of the courthouse.
Scrutiny. So like there's different levels in which the government is allowed to restrict speech, and this is the highest. They're literally saying this is the content that we want to ban, anything discussing the case, and they're not narrowly tailoring it at all. The only way the government would be allowed to get away with this is if it was truly impeding the ability for the court to go forward with the case, truly impeding on the defense for being able to have a fair trial. But we haven't seen any of that. We haven't seen any protester or person with a sign actually bothering anyone or causing a scene in the courthouse. And furthermore, there's no flipping jurors there. There's no jurors there to be even
this courthouse has a back door. I know, because I came in it in chains. There's a fucking back door. If they want to bring the jurors in that way, they can bring them in that way. Nobody protests at the back door. It's just fucking madness. Right. 500 feet.
It's crazy.
I could see maybe them saying like in the courtroom, you can't have a poster while there's jury. Fine. That would be narrowly tailored. But this is so wide. This is so egregious. And it just seems like it's just kind of like the picketing statute itself is unconstitutional. You and I already discussed that.
This is it right here. This
the
is
exact same one.
I'm being charged with 4 counts of this for the rolling rally. It says whoever with the intent of interfering with, obstructing, or impeding the administration of justice, or with the intent of influencing any judge, juror, witness, blah, 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 pickets or parades in or near a building. What the fuck does near a building mean? Housing a court of the Commonwealth, or in or near a building or residence occupied or used by such judge. So I'm being charged with violating this by going to Brian Albert's house, even though he wasn't home. It says you have to be in the residence. And it's just like they weren't even.
Yeah, and if you live down the street from a juror, a witness, whatever, I mean, how are you supposed to get home? Like, you can't even go past their house? What? You can't wear a Free Karen Reed shirt past someone's house, or have a water bottle that says Free Karen Reed, or journalism is not a crime.
Fucking home. And this,
You
so
were
it's just like,
influencing the building, and the building could later influence him. So,
what the fuck
you
does
know.
near a building mean? What does near a,
That's-
like, I guess now we know. Now we know it means 500 feet. That's what I mean. This vague language in these statutes is just like, it just gives it, he could say 1,000 feet. He could say a fucking mile. What if somebody's like 500 feet is a big radius? What if somebody walks within a 400 fucking foot radius, is walking to the goddamn park or something, and they're wearing a Karen Reed shirt? They've just committed a crime. Give me a break. It's unconstitutional. Mark's going to have to do this.
It's clearly unconstitutional. The statute that they're citing for this is unconstitutional. The application of the unconstitutional statute is unconstitutional, because you could have a statute that's unconstitutional and still apply it in a constitutional manner. I know that sounds odd, but in this case, they're doing neither. They're using an unconstitutional statute and applying it unconstitutionally. It's actually pretty wild. This is the most egregious First Amendment.
I was the test guinea pig. Like, they're like, let's just try to test it on him. And no, okay, there's no ACLU's not saying shit. Like, so let's just go. Let's just keep doing it. Let's just round up the Canton 9. Let's charge more people with this. Now they're just flat out saying you can't wear a fucking sweatshirt within a 500-foot radius. And they're just taking this statute that has existed for like 2 decades, and they're just like, oh, now we can use it to just silence speech and people that are too effective in saying the things that they're saying and exposing corruption. It's just madness, absolute madness. I mean,
they're weaponizing the statutes to shut people up, to make the narrative that they want to make out to the media, because they know that they have lost control of the narrative. They know that. So they're trying so hard to keep all the protesters out now. So what's next? I cannot believe this government, this entity right here, this Michael Morrissey and all the folks under him. I just cannot believe how blatantly corrupt they are. And I'm really waiting for the feds to come in and do something. I'm sure you guys are too. Let me know in the comments below what you think about this new filing. It hasn't been approved by any judge yet, although it's probably under Judge Cannoni's review or somebody's review. I don't know. Whatever judge it's going to go to, but probably Cannoni. Anyways, please let me know your thoughts below, and I will see you in the next one. Take care. Thank you so much for watching. Bye now. If you've been impacted by a true crime and would like your story told in your own words, or if you or someone you know has been wrongfully convicted or accused of a crime, please write to crimeincourtchannel@gmail.com and tell us your real true crime encounters. Thanks for watching.